Uwaka at 36. So it is permissible to cause death or bodily harm to someone in order to defend oneself or another person from unlawful violence, provided that the person causing the harm or death did what is necessary to avoid the violence. That is what we mean when we say retreat. The person must have retreated as much as possible. And this is described as private defense in section 59 of Penal Code. For self-defense, see also section 32.3 Criminal Code and section 33.2 Constitution of Federal Republic of Nigeria, 1999. However, it must be noted that in the English case of R versus McInnes, McInnes is spelled MCINNES, 1971, 3 AER at 295. 1971, 3 AER at 295. The requirement of retreat has been jettisoned. The requirement of retreat has been jettisoned. You must also note that for killing in defense of property to be justified, the trespasser must be first requested to leave, and it is after resistance that the attack can take place. It is after the resistance that the attack can take place. Thus, in Baridon versus the state, Baridon is spelled Baridon versus the state, 1994, 1 SCNJ 12-13, the Supreme Court held that the defense of self raised in an appropriate case is a complete answer to a charge of murder. Defense of self raised in an appropriate situation is a complete answer to a charge of murder. So apart from self-defense and defense of property, another instance of lawful homicide is death that results while effecting a lawful arrest. Death that results while effecting a lawful arrest. Section 181, Criminal Law of Lagos State. It can also be a death that results while executing the process of a court of competent jurisdiction. Section 33, Criminal Code. Section 181, Criminal Law of Lagos State. Either while effecting a lawful arrest or while executing the process of a court of competent jurisdiction. Okay, now, the third instance is a death that results during the course of preventing a felon from escaping. A death that results in the course of preventing a felon from escaping. You know a felon, somebody who has committed a felony, maybe he's kept in detention, or you have apprehended him, he wants to escape, then you just shoot at him. Maybe you wanted to demobilize him. You aim at the leg and it hits his head and the person dies. In that kind of situation, it is a lawful homicide, it's excused. Homicide can also be justified where a law officer or police acts to suppress riot, insurrection, or mutiny. Suppression of riot, insurrection, or mutiny, or to prevent a breach of peace, provided that unreasonable or excessive force is not used. Provided that unreasonable or excessive force is not used. So we also have homicide resulting from sporting activities like wrestling, soccer, boxing, etc. provided that neither of the parties had intention to kill. There must not be malice aforethought. There must not be malice aforethought. We can also have lawful homicide from death resulting from disciplinary or corrective measures of the children. Disciplinary or corrective measures of the children. Or what? See section 292 section 295 Criminal Code. You can also see section 24 of Criminal Code, which excuses homicide resulting from accident. Homicide resulting from accident. So in Aliu Bello and 13 others versus AG Oyo State, in Aliu Bello and 13 others versus Attorney General of Oyo State, 1986, 5 MWLR, part 45 at 826. Sorry, 826 at 860. Caribbean White JSC, as it then was, stated that an accident as a result of an unwilled act means an event without the fault of the person alleged to have caused it. An accident as a result of an unwilled act means an event without the fault of the person alleged to have caused it. So the last instance of lawful homicide is killing in execution of a sentence of death penalty. Killing in execution of a sentence of death penalty. And on that, you see section 254 Criminal Code, section 33(2) CFRN 1999, section 175 Criminal Law of Lagos State. And that is to tell you that as far as we are concerned in Nigeria, capital punishment is constitutional and it is still being used. And the ACJA 2015 also prescribed that death sentence can be executed through the process of hanging Hello?
Hello, sir.
I said the ACJA of 2015 prescribed two methods of executing death sentence. That it has to be either by hanging or lethal injection. Although we have not started practicing lethal injection in Nigeria because it's very expensive, we don't have the technical know-how of practicing it. But it has gained a lot of grounds in America. Okay? So that is that for lawful homicide. But the thrust of our concern for the purpose of criminal law is unlawful homicide. And this includes murder, manslaughter, and infanticide. It includes murder, manslaughter, and infanticide. Okay, for murder, sections 315 and 316. Manslaughter, sections 317 and 318. Then infanticide is section 327A, Criminal Code. Aiding and abetting suicide under the Criminal Code attracts the punishment of life imprisonment. But attempt to commit suicide attracts 1 year under the Criminal Code. It attracts 1 year imprisonment. So why do you think somebody who attempts suicide has a very light sentence and somebody who just aids is having a life imprisonment? Why do you think so? Why do you think it is so? Can somebody make an attempt?
Good afternoon, sir.
Yes.
Well, in my own opinion, I will feel the law generally, the idea behind such a thing is to ensure that such a person does not feel guilty because you do not know the situation he or she was that made him to try to commit suicide. It's just a form of rehabilitation.
Yes, I think to some extent you are right. And that is why the criminal law of Lagos State now has even removed imprisonment term as a punishment, and rather whoever attempts suicide is punishable with hospitalization. It's not even a punishment. The prescription is hospitalization, because maybe it's as a result of depression or whatever. Then why is suicide itself not an offense? Can somebody make a guess? Attempted suicide is an offense under the criminal code. Aiding the commission of suicide is an offense punishable with life imprisonment. But suicide itself is not an offense. Why?
Good afternoon, sir.
Good afternoon, sir.
Yes. Yes.
Suicide is not an offense because the victim eventually dies and there is no one to be punished for it.
Okay, that's a very brilliant one. Suicide, if it is completed, the rest is extinguished. So there is nobody to punish. And that is the reason. So, under the criminal law of Lagos State, like I said, attempt to commit suicide is no longer punishable. The section provides for hospitalization order. It is necessary to note, however, that suicide per se is not a punishable offense. So when we talk about infanticide, by virtue of section 327A of the Criminal Code, it is a crime by a mother against her baby who is below 12 months old. You can see a crime committed by a mother. So it must be by a mother. So a father cannot commit infanticide over his own baby. And the baby must not be above 12 months old. So these are the conditions in which a mother may be commuted to infanticide. It is punishable with life imprisonment. It is punishable with life imprisonment. You see, you have to note also that when you are sentenced to life imprisonment, it doesn't mean that you will spend the rest of your life in prison as it stands. The Interpretation Act says that life imprisonment is the maximum if it is stated to be life imprisonment, but that the judges and magistrates have what we call discretion to award a lesser term. But when it is death penalty, that is what we call determinate sentence. That one is not negotiable. It's either death sentence or not. But if it is life imprisonment, in fact, there have been judicial authority, I think it's Ozuloye versus State, where it was held that life imprisonment, it was interpreted to be a term of 20 years. It was interpreted to be a term of 20 years. Some jurisdictions make their own 25, and so on and so forth. So that is the position. So you see the case of R versus Chima. Chima is spelled C-H-I-M-A. Chima is spelled C-H-I-M-A. 1944. 10 Waka 223. Chima is C-H-I-M-A. 1944. 10 Waka 223. It is instructive to state at this juncture that we shall only elaborate on the offenses of murder and manslaughter. So we are starting with murder now. We are starting with murder. So, like I've told you earlier on, for any offense, you must note, okay, when you are being taught elements of crime, did you come across a Latin sentence like actus non facitrium nisi mensitria? Did you come across it?
Yes,
Are you referred? And which means what?
a person cannot be criminally liable if the mind is not guilty.
That is not the exact definition of that Latin word. Actus non facitrium nisi mensitria.
Yes, sir.
An act alone does not make a person culpable for an offense unless it is accompanied by a guilty mind. That is the translation. So two elements are present. The act, that is the actus reus, then the mind, that is the mens rea. Actus reus, mens rea. You know, mens rea is the intention. Guilty mind. Okay? So in your own definition, you didn't mention act at all. And act, I said actus non facitrium. So there is act, then there is mind. So actus reus and mens rea. So for any offense that you want to discuss, you must always address both the actus reus element and the mens rea element. So for the purpose of murder that we are talking about now, the actus reus of the offense of murder is stated in section 315 of the Criminal Code. And it says that when a person unlawfully kills another, then he is said to have committed murder. But the mens rea is contained in section 316 Criminal Code, and there you see 6 intentions listed there. So the actus reus in section 315 will be married together with the intentions, any of the intentions contained in section 316 Criminal Code. So the 6 intentions, we'll visit them later, but let us go ahead with the actus reus element of the offense of murder. Then we'll visit the mens rea element later. So how do we establish a murder charge? Establishment of a murder charge. How do we establish a murder charge? There are 3 stages. We have different authors. So some authors will tell you that there are 6 elements. Some will tell you 5. Some will say 4. But as far as I'm concerned, I've decided to break the elements into 3 stages. 3 stages, establishment of a murder charge. The first stage is the fact of death and the cause of death. Fact of death and cause of death. The causal link, that is the second one, is the causal link between the act of omission of the accused person and the deceased person. And the third one is the presence of mens rea on the part of the accused person. If you say fact of death and the cause of death, it must be established that the person died. Like I was telling you, you know, if they say you kill somebody and the person is still alive, you cannot be guilty of murder. If somebody is dead already and you now stab the person and they now say you have committed murder, you can't kill a corpse. So there must be a proof evidence that the person is dead and the cause of the death must be indicated. Okay? So in establishing death, how do you establish death? Death can be established by a medical report issued by a medical practitioner, certifying that the deceased actually died. Medical certificate of death usually contain cause of death, both primary and secondary causes. And the fact of death can also be proved either by direct evidence or circumstantial evidence. You know, so because there have been instances in which even the corpse could not be found. So how do you prove that somebody died when you can't even find the corpse? Talk less of knowing how the person died. Was it by stabbing? Was it by strangulation? You know, so these are issues. And that is why circumstantial evidence is admissible in establishing, you know, death. So in the case of Azu versus the state, in the case of Azu versus the state, 1993, seized NWLR part 299 at 303. Azu and state, 1993, 6 NWLR part 299 at 303. That was where the imprimatur, the legal imprimatur to the fact that fact of death can be proved through circumstantial evidence was stated. Okay. Then you can also see the case of Itu versus state. Itu and state is 216, 2016, 5 NWLR, part 1506 at 443. Itu versus state, 2016, 5 NWLR, part 1506, 443. Fact of death may be established by a direct confessional statement of the accused person. It may be established also by evidence of eyewitness or the production of the corpse. At least when you say somebody has died and you have brought the corpse of the person, I don't think we need any other evidence to show that the person is dead. Although in some instances you still need medical personnel to certify him dead, but there are some deaths. I think somebody must have congealed. If the body has congealed and the person is like a frozen fish, you know, deaths that are not fresh. Yeah? So in that case, you don't need any evidence to show that the person is dead. The only thing that remains is to start decomposing. So, however, in Ogundipe versus State, 1991, 3 Nigerian Weekly Law Report, part 181 at 519, the deceased was not seen to be alive again after the attack. The deceased was not seen to be alive again after the attack, nor the corpse. The appeal against conviction was dismissed by the appellate court. The appeal against conviction was dismissed by the appellate court, despite the fact that the corpse was not seen and the deceased was not seen alive. This is an exception to the rule that, you know, production of the corpse is required to establish death. Also in Prince Will, you can also see Prince Will versus the state. Prince Will versus the state is 1994. Prince Will versus the state is 1994. 6 NWLR, part 353 at 703. At 703. In Adeboye Amusa versus the state, 2003, 1 SCNJ at 518, where a vehicle left its way, veered off, and hit somebody who died instantly. The court held that the cause of death was already known, despite the fact that there was no autopsy report. The court held that the cause of death was already known, despite the fact that there was no autopsy report. So like I told you, the first element is the fact of death and the cause of death. And I said medical report will reveal the cause of death, both primary and secondary. Okay. So where the confessional statement of the accused person describes how the crime was perpetrated and goes further to state the motive for the crime, medical evidence will not be required. And for that proposition, you see Bubakarim Homan. Bubakarim is spelled B-U-B-A-K-A-R-I-N, Bubakarim Homan, H-O-M-M-A-N, Bubakarim Homan versus the state. Bubakarim Homan versus the state is 1967, NMLR at 23. NMLR at 23. So, in as much as medical evidence is necessary to establish cause of death, there are plethora of authorities to the effect that it is not mandatory in every situation. Circumstantial evidence may suffice in certain instances. So in Jua versus state, Jua is spelled J-U-A versus the state, 2010, for NWLR, part 1184, 217 at 222. The court held 217 at 222. The court held that an accused person can be convicted for the offense of culpable homicide. What we call murder in southern Nigeria is called culpable homicide under the penal code in the north. The court held that an accused person can be convicted for the offense of culpable homicide punishable with death if there exists cogent and compelling circumstantial evidence to the fact that the accused person killed the victim. So we have trashed out the issue of fact of death and cause of death. The second element that is very germane is causal link between the accused person and the deceased. Causal link between the accused person and the death of the deceased. I see, and I like giving this example to my students. If two people have a brawl or altercation, and one of them tells the other, let's say one is Ojo, one is Ajayi. Ojo tells Ajayi and says, look, Ajayi, you have crossed the red line. You don't know me. You are talking to me like that. You don't know, go and find out. I'm the son of Oluwo of our village. No one crosses my path without suffering for it. For what you have done today, if you sleep and wake up tomorrow, call me bastard. You know, people will take it as an empty threat. Ojo told Ajayi that. And Ajayi got home in the night before he went to bed. He told his wife, he said, see what happened today. Me and Ajayi, we had an argument and we abused each other. And he threatened me that if I wake up tomorrow, that I should call him bastard. And the wife said, don't mind him, he's an empty threat. And the guy slept. By 12 midnight exactly, he screamed from his sleep and said, Oro, and dies. And he died. And there is evidence that Ojo threatened him and told him that he will not see the next day. Can Ajayi's wife go to police station and report a case of murder against Ojo? Can somebody answer that question? Hello?
Hello, sir.
Yes.
Hello, sir. I don't
Yes.
think so, sir.
Why?
Because the law believe in like real evidence and not just based on like not based on diabolic or stuff or something like that. So the law believe in real something that happened real, not like diabolic or something like that. Sha.
So that is where we are now. Causal link between the accused person and the death of the deceased. There is no contact as at the time he died. He said, "Oh," and he died. There was no contact. Ojo, who is being accused of killing Ajayi, as at the time Ajayi died, Ojo was in Akunwonjo. Ajayi died in Mushin. They were not in the same place. There is even the arrow that was shot at Ajayi, that killed Ajayi, was not a physical arrow. It was not visible. They cannot produce it in evidence. So the court is interested in evidence. Did he stab you? Did it give you a headbutt? Or how do you say that A killed B? How do you prove? And that is what we are saying. The second integral element of establishing murder is you must establish a causal link between the accused person, the act of the accused person, act of omission of the accused person, and the death of the deceased. If you cannot do that, it will fail. It will fail. So it must be established by the prosecution that the act of the accused person directly or indirectly caused the death of deceased, and that is what we call causation in law, in homicide. That's what we call causation. Causation is Causation, and that you can see in section 308 of the Criminal Code. Section 308 of the Criminal Code. So inasmuch as the act of the accused does not need to be the sole cause, it must be a substantial cause of the deceased death. There is what we call de minimis rule. De minimis rule. Minimis is de minimis is spelled DE, then you leave a space, minimis, MINIMIS. Then rule, the minimis rule. What they are saying is that the acts of the accused person leading to the death of the deceased must not be minor. It must not be insignificant. It must be major. It must be substantial to be able to prove that it is that act or omission that killed the deceased. It must be a substantial act, not just a very minor, contribution to the death of the accused person. Or you can say that it was what who killed him. Okay, so where the accused act is a negligible cause, the charge of murder will fail. The authority for the minimis rule is R versus DR. R and DR is 1996, CLR 596. CLR.
R and what?
Hello?
Hello, sir.
Because somebody muted everybody. So, in the case of Ahmed versus the state, 2001, 18 NWLR, part
So
746.
you mentioned R and something.
R and Dia. R versus Dia is 1996. CLR 596. R versus Dia. Dia is spelled D-E-A-R. D-E-A-R. 1996 CLR 596. And the proposition for that authority is that the act of the accused person must be a substantial cause of the deceased's death. So where the accused act is a negligible cause, the charge of murder will fail. So in Ahmed versus the state, there was evidence that the accused inflicted injuries on the deceased through gunshot on the head. But the evidence was not conclusive that the injuries on the deceased caused the death, which occurred 72 hours later. And based on that, the Supreme Court set aside the appellant's conviction. It's not as if gunshot.
Can you please give the citation for the Ahmed case, Ahmed and State?
2001, Ahmed versus the state, 2001, 18 NWLR, part 746 at 622. There was evidence that the accused inflicted injuries on the deceased through gunshots on the head. But the evidence was not conclusive that the injuries on the deceased caused the death, which occurred 72 hours later. The Supreme Court set aside the appellant's conviction based on this. So what we are saying here is that we are not saying that gunshot is not enough to kill a person. And that is why prosecution has a lot of job to do. You don't only need to establish that the accused person shot the deceased, but you must be able to also establish that the gunshot caused the death of the deceased. So that was the lacuna that made the appeal court to set aside the conviction in this case, the Supreme Court rather. So death may be caused by direct or indirect means, and it can be caused either by the assailant act or omission. So in section 211 of the Criminal Law Code of Lagos State, Criminal Law of Lagos State, it provides that any person who causes the death of another, directly or indirectly, by any means whatsoever, is deemed to have killed that other person. So you can also see section 310 Criminal Code for that. Section 310 Criminal Code. So what we are saying in essence is that death could be caused by poisoning, drowning, burning, starvation. You can stab somebody to death, strangulation, or asphyxiation. That is, if you block the person's breath, that's asphyxiation. Or suffocation, as the case may be. See Usman Morgan versus the state. Usman Morgan versus the state, 2010, 16 NWLR, part 1220 at 439. Part 1220 at 439. The prosecution must prove not only that the conduct of the accused could have caused the death or disease, but that it actually caused the death. You see, you don't subject to speculation. Don't subject the court to speculate. Therefore, my lord, the act of the accused person must have been the cause of the death. No, you don't speculate. You don't assume. You don't prove by conjecture. You must go ahead pointedly to establish the fact that that act of omission actually caused the death of the deceased. And on that, you see the case of R versus Oledima. R versus Oledima, 1940, 6 Waka 202. Oledima, OLEDI, MA, 1940, 6 Waka 202. Yes, we are talking about causation all along. I told you that there is need for establishment of a causal link between the act of omission of the accused and the death of the deceased. And I told you that is what is called causation. But there are instances in the law of murder where the chain of causation can be broken. If the chain of causation is broken, the accused person is no longer liable for the death of the deceased. And I'm going to give you about 6 instances in which the chain of causation can be broken. Take note that I say, if the chain is held to have been broken, it means that the accused person is no longer responsible for the death of the accused person, of the deceased, despite the fact that he was the one that set the machinery in motion for the death. He initiated it. But along the line, there was an intervention which made him no longer to be liable. We are going to see. So the first break in causation, chain of causation, is called a year and a day rule. A year and a day rule. A year and a day rule. Under the common law and criminal code, a person is deemed to have killed another only if the death takes place within a year and a day. Within a year and a day. If it is ordinary year, it is 365 plus 1, making 366. But if it's a leap year, it will be 366 plus 1, making 367. If the death occurred on the 367th day of an ordinary year, then the accused person is already discharged. The chain of causation is broken. Are you with me? Hello?
No,
Sir, come again.
Sir, please
You know,
come again.
we say 365 days makes a year. Yes or no? Yes or no?
Yes, sir.
Yes, sir.
365 days makes a year. And if we are talking of a year and a day, then that makes it 366 days. And what this position, what this break in causation, chain of causation is saying is that if, for example, if I stab you or I give you poison to eat, and you die after a year and a day, that I'm no longer liable for your death. You see, the essence of this particular requirement is not to hold a person perpetually liable for acts that can lead to death. So there is something like streamlining, so that if death does not occur within that time frame, then you are no longer liable for the death. That's what they are saying. That's why I said a leap year is 366 days. An ordinary year is 365. So 365 plus 1 is 366. So if I stab you and you die on the 367th day, the chain of causation is broken. Is it clearer?
Yes, sir.
Okay, so what I'm saying is that such period, a year and a day, is reckoned to be inclusive of the day on which the last unlawful act that contributed to the cause of death was done, inclusive of the day on which the last omission ceased. So for a year and a day rule, you see section 314 of the Criminal Code. Section 314 of the Criminal Code. However, a year and a day rule is a relic of antiquity. A relic of antiquity when medical science was rudimentary. The purport is a substantial lapse of time. The purport is that if there is substantial lapse of time between the injury and the death, the person who has injured another must not be made to remain indefinitely at the risk of prosecution for murder. And it will be unsafe to pronounce on whether the defendant's conduct or some other event caused the death. Consequently, if death does not occur within a year and a day from the date of the injury, the death will be attributed to another cause. So it is to be noted that the criminal code still retains a year and a day requirement, while the criminal law of Lagos State has jettisoned. Take note of this. Take note of this, because we have a way of, trying to test you in exam. Criminal law is very technical. It's simple, but technical. We can ask you if something happens in Lagos State and the person is tried under the criminal law of Lagos State. Will your position be different from if the person is tried under the criminal code? You understand what I'm saying? So we just want you we want to test your knowledge of telling us that it is not the same situation. Criminal law of Lagos State has jettisoned the year and a day rule requirement, whereas the criminal code is still retaining it. Are you clear about it now? These are the gray areas where we test you in exams. A year and a day rule was also abolished in England by Section 1 of the Modern Abolition of a Year and a Day Rule Act 1996. A year and a day rule was also abolished in England by virtue of Section 1 of Modern Abolition of a Year and a Day Rule Act 1996. So in Eric Uyo versus A.G. Bender State, Eric Uyo versus A.G. Bender State, 1986, 1 NWLR, part 17, 418 at 429. 418 at 429, where the death of the deceased occurred from the act of the appellant within 1 year and a day. It was held that the presumption that the accused caused the death was applicable. It was held that the presumption that the accused caused the death was applicable. Well, it is submitted that the year and a day rule is not only antiquated, but also anachronistic, and as such should be jettisoned. As of today, under the criminal code, if death occurs after a year and a day from the injury inflicted, the chain of causation is broken. However, with modern medical technological advancement, life support facilities are now available to lengthen and save human life. So it has been contended that the rule will merely allow accused persons to escape liability for homicides that were glaringly committed. I hope you can understand that now. That's my rationalization. I'm making a case for outright jettisoning of a year and a day rule, because there is modern development in medicine where somebody's life can be preserved, unlike in the olden days. So if you now limit it to a year and a day rule, somebody who is supposed to ordinarily be liable for murder will be free. So in England, it has been jettisoned. Criminal law of Lagos State has also jettisoned. So it is time for the criminal code to be reformed, in order that a year and a day rule will also be removed from our own corpus of criminal law statute. So the second instance of break in chain of causation is what is called novus actus interveniens. Novus actus. Novus actus. You have the spelling, or you want the spelling?
We want the spelling, sir.
Okay, novus actus interveniens is spelled, novus is N-O-V-U-S. Actus is A-C-T-U-S. And interveniens is I-N-T-E-R-V-E-N-I-E-N-S. N-I-E-N-S, I-N-T-E-R-V-E-N-I-E-N-S, Novus Actus Intervenens. It's a Latin word, and what it simply means is the intervention of an act or event. Intervention of an act or event. Novus Actus. An act that is new and different from what is existing. You know, so it can make a chain of causation to break. So chain of causation will be broken where there is an intervening development that sets in to make the defendant's act not to be the main cause of death. Where there is an intervening development that sets in to make the defendant's act not to be the main cause of death. So in R versus Jordan, 1956, 40 CAR 152. R versus Jordan, 1956, 40 CAR 152. Where the accused stabbed the deceased, but there was evidence that the death of the victim was as a result of poor medical treatment given to him, which resulted in bronchopneumonia, when his wound was almost getting healed. When his wound was almost getting healed, it was held that the chain of causation was broken. It was held that the chain was broken. And on that, you see also the Nigerian case of Ikono versus State. Ikono versus State is 2021, 13 NWLR, part 1792 at 185. The difference between Ikono and State is that, and Jordan, is that in Jordan, the poor medical treatment resulted in bronchopneumonia, whereas in Ikono, poor medical treatment resulted in leg amputation due to injury, due to infection, rather, leg amputation as a result of infection. However, Section 313 of the Criminal Code contemplates situations where there are proper medical attention. Contemplates situations where there are proper medical attention and makes the defendant liable even if there is evidence of death by surgical complications. So the chain remains unbroken, provided the treatment was reasonably proper and done in good faith. So if you look at the facts of Jordan, poor medical treatment, which resulted in bronchopneumonia, and the court held that the chain is broken. So which means if the medical treatment had been good and there was not a resultant effect of any other disease which eventually caused the death, then the chain will not be broken. So you have to take note of that. But we have some controversial cases. You know, in R versus Smith, for example, R and Smith is 1959. R and Smith is 1959 to All England Report 193, to All England Report 193, where the accused stabbed the victim. And the victim dropped twice on his way while being taken to the hospital and was given bad treatment on admission, which affected his chance of recovery, and he died. It was held that the act of the accused was the operating and substantial cause of the death. Can you see that? So, to what extent can we distinguish the fact of Smith from the facts of Jordan? Jordan, poor medical treatment. Smith, they said he was given bad treatment. The only difference is that in Jordan, as a result of poor medical treatment, there was another development, there was another a disease, infection of bronchopneumonia, you know, and it was that bronchopneumonia that eventually killed the deceased. So Novus Actus operated there. But in Smith, though there was bad treatment, but the court held that the act of the accused was the operating and substantial cause of the death. And the same thing happened in R versus Holland. R and Holland is 1957. CLR 707. R and Holland is 1957. CLR 707, where the accused caused the injury to the victim's finger. The accused caused the injury to the victim's finger. Having not been properly handled, it turned to lockjaw infection. See now, having not been properly handled, it turned to lockjaw infection. But it was held, surprisingly, that the chain was not broken. So it is curious whether the facts of the above two cases